Welcome everyone to Aviatra Accelerator's monthly webinar. This one is called Contracts 101. I'm Jill with Aviatra, and what we do here is we help women entrepreneurs start and grow their businesses faster and with more confidence. We offer classes, coaching, and a community, and a lot of other resources, including webinars like today. So we have talking with many entrepreneurs all the time. We have realized that one of the biggest mistakes that business owners can make is not having a strong contract. And I'm sure Shelby is going to share some more about what can happen if you don't. So we are going to learn today about what makes a strong contract and how you can protect yourself and your business in that way. So I would like to introduce Shelby Campbell. She's a business attorney with Smith Law in Covington, Kentucky. And Shelby, I'm going to give the floor to you.
Thanks. I'm Shelby Campbell. I work with Shannon Smith, the law offices of Shannon Smith in Covington, Kentucky. If you're unfamiliar with Shannon, she's a city commissioner in Covington. She also owns Revival Vintage Spirits. So what I think really makes our firm special is that we're women owned and operated, but also we are entrepreneurs ourselves. Shannon has, operated several businesses, and we understand the ins and outs of small businesses and the struggles that small businesses have, but also the struggles that women have in small businesses. So with that, I want to go ahead and get started. So I'm going to share my screen, and I'll make these slides available as well later.
Thank you for that.
Yes. All right. There we go. So Contracts 101, protect your business and yourself. The importance of contracts. We all understand they're not fun. They're not super exciting topics, to delve into, but they are essential. Small businesses enter into contracts every single day, and even as individuals, you probably are entering into a contract weekly, just with the terms and conditions that you're signing whenever you are shopping online or anything like that. So it really is pretty central to a business and to an individual. So I'll try and make this as fun as possible, but feel free if you have any questions at all. Feel free to interject, or I also plan to have some questions at the end. So we'll go ahead and get started. So the importance of contracts. First, they're going to help you protect your business interests. Whenever you're starting a business, most people have some kind of mission in mind, whether it is, if you're a restaurant and your mission is farm to table, you're going to want to make sure that the contracts that you're entering into with your vendors and even your employees are going to reflect, the mission that you have. So contracts can help safeguard your rights, your obligations, your expectations. Whenever you're getting this business started, that contract is going to be your operating agreements, your licensing agreements, your articles of incorporation. Those sorts of things are going to be the constitution of your business, the guidelines that guide you as you are operating your business. And we'll delve into different types of contracts here in a minute. But contracts help you to establish clear expectations. So, when you're entering into a contract with somebody, if there's no mutual consent between the two parties, if you're not fully understanding the expectations of each, you could run into some serious issues. So we're going to take care of that as well. Manage risk and liability. Of course, every contract needs to help you minimize risk and minimize that liability. And lastly, you want to be able to enforce your contractual obligations. So what I mean here is, if you don't have that contract in writing in place, it's really hard to become enforceable. Of course, you can enter into a verbal contract, but unless you have it in writing, it makes it really difficult to become enforceable. So we're going to talk about that as well. So common types of contracts for business owners. Like I said, your bylaws and operating agreements are going to be essentially the constitution of your business. It's going to be, the laws that your business has to abide by. Your operating agreement, sorry, that's going to be what initiates your business to begin with. If you have any disputes between you and your partner, you and other owners, you and anyone in the business, that is what you're going to look to try and settle those discussions, those disagreements. I highly recommend putting some kind of tiebreaker into your bylaws and your operating agreements, so that if there is ever any kind of disagreement between you and your business partner, there is always somebody who can help settle those decisions. At the very least, you're going to have some kind of mediation clause or some kind of provision that lets you know what's going to happen if there is a disagreement. We want to get ahead of ourselves so that, you're not filing in court without, any real true needs or means to do that. If we can settle something outside of court, we're always going to want to try and do that. So that's going to be included in your bylaws and your operating agreements. As far as real estate agreements goes, I think we're all pretty familiar with deeds and leases. But one thing I did kind of want to mention to any small business owners who have a brick and mortar location or an office space, when you're looking at the lease for those spaces, you want to look at your common area maintenance charges. So any common areas that you share with other tenants of the building, any living spaces, bathrooms, kitchens, those things, you want to make sure that you're not going to be held liable for somebody else's utilities. If there is a leak from the floor above you, you want to make sure that you're not having to repair your own ceiling because somebody else left their faucet running or something like that. So that's one thing I always tell my clients to pay close attention to, is those common area maintenance charges in any kind of real estate agreement that you're going to enter into. Contracts for purchase and sale, this can get a little bit complex, so I'm not going to delve into it unless somebody, has some questions, and I'll be happy to answer any questions that you might have. But asset purchase agreements, stock share agreements, these are things whenever you're bringing in a new partner, or if you are trying to leave the business and sell your assets in the business, your interest, what have you. Those are the contracts that we're going to look at for that. Rental agreements when it comes to equipment, tools, renting goods rather than renting a property. These are going to be, if you you may need to rent tools or software, hardware, that sort of thing. You're going to want to make sure, if you are the one who is renting out that equipment, you want to make sure that you have repossession rights, any kind of liens that you might want to put on that property. If your contractee defaults on their payments, you want to make sure you have those provisions in there so you know what your rights are should anything go wrong. And that's really the theme throughout contracts in general. You just want to know what your rights are in case anything goes wrong. So with the purchase and sale of goods equipment, so if you're a retail shop and you are selling products, goods, equipment, you're probably having suppliers that you're getting those goods from. Those contracts between you and your suppliers are also very important. And we'll talk a little bit about offer and acceptance when it comes to making a contract and how you can accept offers from sellers, even unintentionally. So I want to delve into that a little bit later, but just at the top of this, I do want to point out that any contracts that you're entering into with these suppliers, they can be negotiated. Almost any contract can be negotiated, and don't be afraid to ask. The worst thing they can do is say no. Employment and independent contractor contracts. So this is actually a huge topic right now. There's recently been a federal ban on non-compete clauses. So I'm going to talk a little bit about that towards the end here, but I do just want to emphasize employment agreements are still lawful. You can still have employment contracts. You can still have independent contractor contracts. And whether or not it's more beneficial to have an employee versus an independent contractor is something I'm happy to discuss as well. You really have more control over employees than you would an independent contractor, but you also have more liabilities with employees. So if anybody has any questions on that, I'm happy to delve into that too. So the key elements of a contract, like I said, there's offer and acceptance. That's, the most basic portion of a contract that everyone's familiar with. I do want to mention too that contracts, like I said, can be verbal or written. And there are certain industries that have more familiarity, I guess, with verbal contracts. I've worked with a lot of people in construction, a lot of people in equine, and some people in the service industry as well, rely heavily on verbal agreements or, gentlemen's agreements. I've had people come to me several times and say, "Oh, I've had a gentleman's agreement with so-and-so. Nothing's in writing, but, they're not following through." It's still a contract. It makes it a whole lot more difficult to be enforceable whenever we don't know for sure what the terms were. But it's absolutely still a contract, and it's something that we can absolutely help you with. But the key elements when you're making a contract, first step is an offer. Somebody's got to make an offer. It will be a very clear proposal from one party to another, and it should indicate their intention to enter into a contract. Now, acceptance can be a little bit more complicated. You can accept the contract either, verbally, or written with a signature. But the acceptance must be communicated in the manner that the offer requested. So if the offer is in writing and it asks for a signature, the acceptance has to be in writing and a signature as well. It's pretty straightforward, but you'd be surprised it gets a little bit more complicated. Consideration is also key to a contract. You have to have consideration for a contract to be enforceable. When I mention consideration, I mean an exchange of money, goods, services, promises to act, or promises to refrain from acting. So the most common, obviously, is money. You enter into a contract with a supplier and say, "I will give you $1,000 if you give me 100 t-shirts," or something like that. Or that'd be very expensive, but you know what I mean. The exchange of goods and money is very common. Exchange of services and money. I'll give you $20 to mow my lawn. Super common. A little bit less common is a promise to act or a promise to refrain from acting. The example they always use in law school is, a grandfather who promises his grandson, "I will give you $1 million when you graduate college if you go through college without taking a sip of alcohol." So, even though he has a right to drink alcohol as a 21-year-old, his promise to refrain from acting on his own rights is enough consideration to make a contract enforceable. So, there's a few different ways we can make contracts enforceable. Like I said, money is one. Some people will offer a sale of a piece of property for $1 and call it consideration. And, sometimes that works if it's, sometimes bigger, more intricate pieces like real estate. It gets a little bit more complicated than selling something for $1. But at the end of the day, as long as there's some kind of consideration, the contract's most likely going to be enforceable as long as all of these elements are met. Legality, that seems pretty straightforward as well. You can't contract somebody to do something illegal. You can't contract somebody to, can do something that is either against public policy or an illegal activity. And by public policy, I would mean you can't, if you were to hire an employee, you couldn't tell them you aren't allowed, you can't have them sign a contract saying you cannot sue me, your employer, for any reason whatsoever. They have a right to sue you if you take certain actions against them. You can't sign away your rights like that. Capacity, your parties need to be of legally sound mind and of legal age. That's pretty straightforward as well. And then mutual consent, like I said, both parties need to fully understand that they are agreeing to a contract. They need to understand that the terms are the same. If there's any kind of discrepancy, particularly in verbal agreements, where maybe something is lost in translation, you want to make sure that all parties understand what they are agreeing to, the terms. Otherwise, the contract could be unenforceable. So, like I said, if you have that in writing, this really is not an issue. But for verbal agreements, mutual consent is often an issue. And then I want to talk a little bit about characteristics of a good contract. Clear and concise language is a very important aspect of contracts, and a lot of people will print off a contract that they find on the internet, and I always advise against that, regardless of what the contract is for, whether it's a lease, whether it's for the sale of goods or services. I always advise against using those template contracts because they don't tailor the terms to your business's needs or to your industry's needs. For instance, I work in ABC law a lot. I have a lot of clients who are brewers or distilleries, and they have very specific language about, say, the word produce is a big one. If somebody is producing bourbon, what does that mean? In some industries, if you're talking to a retail shop, a liquor store, the product could be a glass bottle of bourbon. If you're talking to a manufacturer, the product or what is produced is going to be a barrel of bourbon. So, you need to be very specific. I always, always, always recommend having a definition section in every contract for any kind of ambiguous or industry terms like I'm talking about. The words produce, what is a product? Very simple things that you think everybody should understand. If anything has a special meaning in your industry, I would definitely define that in a contract. I also think that a lot of people think that you need to use these huge, all this legal jargon in your contract. And honestly, the best contracts have simple language that everyone is able to understand, regardless of whether or not you went to law school. The more complicated the words become, the more room there is for ambiguity and confusion. So I recommend just using clear language. We don't need to use the wherewithals and the whereases unless it's absolutely necessary. So, and then specificity is another huge issue. It sounds very similar to just being concise, but you want to be specific in the terms themselves. So when I say this, I mean in the duration of the contract. You want to be specific in the duration of the contract. Is this contract just going to be for 2 months? Is this contract going to be for a year? How long is this contract going to take? Is it going to be determined based on time, or is it going to be determined based on the project itself? Is it just once the project's completed, the contract is completed? Those are things you want to be specific about. You don't want to sign a contract, a construction contract, and saying, yes, I would love for you to build a porch. But if there's no end date, it could be 6 months to a year before you get your porch. So these are just things that you want to be very specific about. Duration is one. Another big issue I've seen is not having the proper legal names of the parties in the contract. That seems super obvious. But for instance, there are a lot of businesses that have a DBA or doing business as name, but then they have a formal legal name as well that is registered with the Secretary of State. So if you just name the DBA name, if the DBA is not registered or if you're not naming it correctly, then that person is not actually a party to your contract. So you want to be specific, make sure you're using the right names. And that's a super easy search. You can just Google business name search in Kentucky, business name search in Ohio for whatever business it is. You type in the name that you think it is, and usually something will pop up. So that's super easy to rectify, but definitely something you want to make sure you get right. And then lastly, you want to have your remedies for breach within the contract. If something goes wrong, what exactly is going to happen? Are you going to go to mediation? Are you going to have specific damages? We'll use the porch example again. If you're a small business and you're trying to build a porch for your restaurant so you can have drinks outside or something like that, you're expanding your space to have double the capacity that you would have inside. But if you are investing all this money into contractors to build you this porch, and the porch takes 6 months to build, and now it's winter and you can't use it, you have certain damages because you weren't able to use the product for its intended purpose, and it wasn't completed in a timely manner. So those are certain things that you're going to want to have specifically mentioned in the contract as to what's going to happen if they don't follow through. Common pitfalls to avoid. There's a lot of these, and I can give you specific examples on each one. The first one is get it in writing. Put everything in writing. At the very least, even if it's just an email or a text message, at least put it in writing that there is an agreement. And of course, I always recommend a full contract for a text message or an email. But I know if you're in an industry that is kind of put off by formal contracts, that happens. at the very least, have a phone conversation and memorialize it in an email afterwards. That's really the bare minimum. Two, read your contracts carefully. I've had a lot of issues with people who think that, well, this contract's not negotiable. I don't have any options. I have to sign the contract regardless. What's the point of even reading it? You ought to read it anyway. I had a client recently who was getting ready to sign a lease, and they're like, this is the perfect spot, the perfect location, the perfect price point. We're going to sign this lease. And I take a look at it, and it says that their common area maintenance charges are insane. They're going to be paying everybody's utilities. They're going to be responsible if somebody else causes damage to their property, even if it's another tenant. So these are things that they would not have caught if they didn't have an attorney look at it, or if they didn't read it thoroughly themselves. You don't need to have an attorney always, but at least read through it carefully. Make sure you understand the terms, and if you have any questions, feel free to ask. And if there are any terms, like I said, if there's a definition that isn't, or a word that's not clearly defined and you're not sure what it means by produce, or what it means by damages or something like that, you're going to want to ask them for clarification, just to make sure that you're not, signing away your rights, or signing away, the rights to damages that are extravagant. Three, document all contract changes. Any amendments to a contract have to be made in writing. This is part of contract law. The original, and most contracts will say this usually towards the end. Any changes to this agreement have to be made in writing and signed by both parties. Courts will not enforce a change to a contract unless it is in writing and signed by both parties. So, if you were to contract with a supplier for 100 chairs to be sat in your dining room, and then you realize that you're expanding and you need 200 chairs, unless you put that extra 100 chairs in writing, they don't have to follow through with that promise. So definitely always get any changes to contracts in writing. Keep meticulous records. This kind of goes hand in hand with keep it in writing. Any conversations about any changes to the contract, always keep them handy. Keep them paper copies, digital copies. I always recommend having multiple versions of it. And if you have an attorney, you can send any contracts to them that are already signed. Send it to them. Have them save it in their records. We're required to keep records for X many years, so you'll make sure that you'll always have them handy. I recently dealt with a client who had a contract completely finished. We negotiated this contract for probably 3 months, but she never got a signed copy of it. So even though she signed it, she didn't have the opposing party sign it. And so we've had to go through some litigation to try and make sure that she's paid for her services. So that's very frustrating, especially when you took the time to sign it and you just never got their records back. So again, don't be afraid to negotiate. Everything is negotiable. The worst thing you can do is say no. Leases are always negotiable. Supplier contracts, if you are a contractor yourself, you can, always tweak your contracts to make them benefit you a little bit better. And I would recommend being open to allowing your clients to negotiate your contract a little bit as well. I know a lot of people, once they have their contracts in writing, they don't want to mess with them. They like them the way they are. But when you negotiate in good faith, it really does build a better rapport with your clients and allows them to feel like they have certain levels of control over what's being done and how the quality in which it's being done as well. So I do typically recommend being open to negotiations on either side. And then lastly, stay up to date on legal changes. I mentioned the non-compete ban a minute ago, and I'm going to go ahead and talk about that a little bit more now. Essentially, the FTC has decided that non-compete clauses are going to be an unenforceable, I believe it begins in June. It might be July. I can give you a little bit more information on that if anybody is interested. But any non-competes that are currently active are going to be unenforceable. And going forward, non-compete clauses are going to be unenforceable as a whole with anyone except CEOs or owners of a company. It used to be that non-compete clauses had to be limited in duration, so time. They had to be, less than usually 2 years, and they needed to be limited in scope as well. And by scope, I mean geography and also the type of non-compete. So usually it was within, X many miles for X amount of time and only within your specific industry. They're doing away with all of that now. Non-competes it's really unfortunate for business owners. A lot of them are stressing about how am I going to keep my employees happy? How am I going to keep them here? And how am I going to know that they are not going to leave my company and start their own company? Those are all very valid concerns. And one huge advantage is that non-disclosure agreements are still going to be permissible. So rather than telling your employees that they can't go work elsewhere, you can tell them you can go work elsewhere, but you can't use anything that you learned here to go work elsewhere. You can't use our trade secrets. You can't use our processes. If you created some kind of software, hardware, or some kind of something that belongs to the company. And these are things that you will want to memorialize in writing, either in their employee contract, in your handbook, or maybe just a privacy policy, a non-disclosure agreement, or something like that, if these are concerns that you have. Not every business owner is concerned about non-compete clauses or non-disclosure agreements, but if it is something that you're concerned about, there are definitely ways to work around it. Another good thing for employers is that the non-solicitation clauses are still going to be allowed, meaning that if your employees cannot solicit their coworkers to go start a new business or something like that. So there is certain limitations, and I'm happy to help anybody work through what those might be, and make sure that we can get those squared away, protect your business interests, and your business secrets as well.
And Shelby,
That
Cynthia
way we
raised
have,
her hand, so I feel like she might have a question about that topic.
yeah.
Cynthia, do you want to come on, Mike?
Yeah. Hi. I just had a question. In terms of there are a number of industries where there's just kind of standard process. It's not like one specific location is doing something different than another location would be. And so I'm just trying to figure out in terms of how would something like a non-disclosure or like help in that sort of an instance.
Yeah. So I think so I'll use, hospitals as an example, because I know a lot of healthcare workers have non-compete clauses.
Yeah, I'm a physician. At one point in time, I was faced with a contract which I did not sign. It would have been downtown, and it would have taken me out from Ronald Reagan all the way to 275 South. I wouldn't have been able to practice any place in that whole area.
Yeah.
And yeah, it's really common. But I mean, if most doctors' offices work in a very similar fashion, so as a small business owner now, trying to think of how in the world somebody would even use that sort of a thing to be helpful. I'm not sure I understand.
Yeah. So in healthcare, I'm not sure that it's going to be super, super helpful, simply because you almost already have a non-disclosure, kind of like attorneys do. We have certain confidentiality and privilege requirements. HIPAA is going to refrain from, you taking any kind of clients or patients. I guess your patients can leave, but starting a new business there's a certain level of confidentiality that you're going to have to follow when starting a new business. And when it comes to medicine, I mean, those are processes that are standardized. So, you really, as far as, a non-disclosure, maybe it's not going to work as well as for the actual medicine portion. It will help protect your business more on the backside. So if you have certain payroll secrets or payroll processes, certain processes for securing patients, certain marketing tactics, any kind of advertising that you've done. Those are the things that you're probably going to be protecting a little bit more than your patients or I guess the employees themselves, if that makes sense. Did I answer your question, or do you have a follow-up? All right. So some real life examples, bylaws and operating agreements. This is something I've already mentioned, but I wanted to just give you a few examples from some real cases that I've been dealing with. I think I've got 3 or 4 slides similar to this, but bylaws and operating agreements is one thing that I see over and over and over again. If you don't have strong bylaws, or if you don't have a strong operating agreement, if you're a corporation, then the term is articles of incorporation rather than an operating agreement, and operating agreements for an LLC. But these are the foundation of your business. These are your constitutions. These are what you're going to look at if there are any disputes. So like I said, I've had a couple clients. One of the more recent ones was a salon with 2 owners who just had some creative differences and they wanted to split ways. Because there were only 2 partners, they couldn't decide how to split the business. One of them felt that they should get all of the physical property, and that the other one could keep the real estate. I mean, because it wasn't itemized and memorialized in the operating agreement, it was very, very contested. So I always recommend, you know, really thinking through worst case scenario. Think of an operating agreement almost kind of like a prenup for your business. This is something you want to make sure is ironclad before you enter into a partnership. Just to make sure, all your I's are dotted, all your T's are crossed, and you know exactly what's going to happen if things go south. Signatures are another big one. And there's a few different sections here, so I'll break it down a little bit. But when you're signing a contract, there's a few things you want to make sure you have completely correct. And as obvious as it sounds, you want to make sure you're signing the proper agreement. A lot of times when we're drafting contracts or we're negotiating contracts, lawyers are sending contracts back and forth to each other with red lines, with edits, different changes. If there is any discrepancy in the contract and one party signs one version of the contract and the other party signs an older version of the contract, that contract's going to be likely completely unenforceable because the terms just aren't the same. You sign 2 different contracts, and it's really hard to overcome that. Another thing is make sure you have the proper parties involved. Like I said, if you are naming a car dealership and the car dealership is, a Mercedes dealership or something like that, it's affiliated with Mercedes, but you're going to want to make sure that you are suing the dealership, you're suing the owner of the dealership, and you are suing Mercedes as well. Or not necessarily suing, but entering into a contract with all of those parties. You want to make sure that you are entering into a contract with the correct party, but also that the person who is signing the contract on behalf of that party has the authority to do so. I ran into an issue with this recently with a manager for a retail store who signed a purchase order on behalf of the company, but they didn't have the authority to do that. So they essentially ordered 100, whatever it was, without permission. And it ended up that because they didn't have the authority to sign that contract, the contract was unenforceable. So it ended up working out, but I think the employee probably didn't. Witnesses and notaries. Some states legally require you to have witnesses or notaries for certain types of contracts. Usually these are wills, powers of attorney, those sorts of documents. But even still, you want to make sure that you're keeping up with your local, state, federal regulations for what needs to be a part of the contract. And that's something you also want to pay attention to if you are looking at contracts on the internet. I know like LegalZoom, or there's a whole bunch of contract generating softwares online, but I'd be very cautious. Make sure the jurisdiction is correct. Make sure you're having your witnesses and your notaries and all of that. Electronic signatures. This became much more prevalent during COVID, and since COVID, we've really kept up with it. There are so many different forms for electronic signatures. Adobe is a huge one, obviously. DocuSign, eSign. Our firm has one that keeps all of our contracts secure within. It looks like we have a chat.
She just has to leave a little early.
Okay, no problem.
Thanks for letting us know, Stephanie.
You just want to make sure that you are following the state regulations for electronic signatures. So those do vary state by state. So if you are a Kentucky business and you're contracting with somebody in Ohio, make sure that you are following both states' requirements for electronic signatures. And, you know, I'm always more than happy to help work through the details with that with anybody who needs it. And like I said, you just want to make sure that it's the right type of contract. Some contracts cannot be signed electronically. So happy to take care of that as well. Counter signature, this is very crucial. This is what I was talking about a few minutes ago with one of my consultant clients who performed a whole bunch of services, but then realized that the other party had never signed the contract. So even though, you know, half the parties had signed the contract, the other half had not, and the contract ended up, luckily we were able to work it out, but it, you know, it could have gotten very complex, and, you know, always make sure that you have a proper signature from a proper party on all of your contracts. And then coexistence and licensing agreements. This is one regarding trademarking. And I'll talk a little bit about trademarking just quickly so that you kind of have a understanding of what goes into trademarking. But the first thing that we do when we work with a client who wishes to have a trademark filed is we conduct a thorough trademark check to make sure that there are no conflicting marks that sound similar, look similar, or could be confusing to consumers. And that's the whole the test for trademarking is this going to be confusing to the consumer? So we're going to do a quick check, make sure that there's nothing confusing to the consumer. We'll file for the trademark, and if the trademark office decides that there could be some kind of confusion amongst the two owners of the trademarks, we could enter into a coexistence agreement. And what this is essentially both owners of each trademark agreeing that we're in different enough industries, or our marks are different enough that we agree that we can coexist in the marketplace without interfering with one another's businesses. So those are very important agreements that you are going to want to have in place prior to beginning all of your branding. So the real life story I want to tell about this is I had a client who built up a very successful wine business, and she had been making wine for probably 5 to 7 years at this point. She built up a great local brand, built a name for herself and her business. But then when she went to trademark, she found out that there was a company in California with a very similar name. So similar that the Patent and Trademark Office wouldn't permit her to trademark her own name. So after 5 to 7 years of business, she's having to completely rebrand. So this is just something, I don't say to scare you, but just to keep that kind of at the forefront of your mind if you are in the business formation stage, that you want to consider looking at names that are not going to have any kind of trademark conflict down the line. And if there is, maybe explore that coexistence agreement before you know, you begin your branding and marketing. And then I have time for questions. I would love to hear from you guys. See if I can get you guys back. Yeah, so any questions that you guys have, I'm happy to answer. And if you'd rather email me, if you know, they're more personal, I'm happy to give you my email address as well, and my phone number should be there at the bottom.
And we will also send out your contact information with the replay. So thank you for that, Shelby.
Yeah, absolutely. And if anybody wants a free consultation, I'm happy to discuss any questions that you might have about your business, about contracts in general, about trademarking. I handle our licensing, our permitting, trademarking, business contracts, business formation, business dissolution, mergers and acquisitions. So, anything that your business might need. I even do employment law if you have issues with employees. Or if you are an employee who's having an issue with your employer, I can do both ways. So, any questions that you guys might have, feel free to
Yeah,
reach
and I just
out.
want to clarify too that Shelby does not offer free consultations as a general rule. She does it for people who come through Aviatra. So thank you, Shelby, very much for that. I wanted to just showcase the value of that. It's not a normal thing. Like get that because of your attendance at the webinar. So thank you for that.
Yeah, we really value women-owned businesses and small businesses in general. You're contributing to your local communities. So we love helping small businesses, and we love helping women-owned businesses as well.
Thank you. If you don't mind stopping sharing, I'll just go back to the gallery and we can open it up. Thank you for questions. If nobody else has a question, I have a question.
Yeah.
So with contracts, when you were talking about the main types of common types of contracts, one that I didn't see there specifically was contracts for service providers. So either licensed professionals like yourself, or even like a marketing consultant or coaching or anything like that. So are there any differences between those types of contracts and a contract for an exchange of goods?
Yeah, so there is a difference, and happy to delve into it a little bit.
Okay, good.
We
Thank you.
we have, of course, like we have our what we call an engagement letter. So whenever we sign with a client, we send them a letter that, I mean, it's probably 4 pages long, that lays out all of our fees, our terms, what happens if they default. Are our services going to completely stop? Are they going to get any kind of window? Is interest going to start accruing? Like what is going to happen if you default on those payments? Those are all things that you want to have in a services contract, because I'm sure with in the medical field, there's certain liabilities if you just stop treating a patient without warning. With lawyers, we can't just stop representing somebody without warning. We have to, withdraw from a case, and there's certain procedures that you have to follow. So those are all things that you would want to include in your services contract. And we work with several consultants on a national level and a couple on an international level. So that, it's really exciting to get to work with those consultants. We typically have a master consulting agreement for each of our consultants. And for each of their projects, we'll tweak it a little bit. So for some projects, our consultant may want to allow her name and NIL. So the NIL is really big right now, especially in sports. But for this particular consultant, she has a certain public persona, and her name being on certain products help those products sell more. So in those consulting agreements, we're also including licensing agreements, royalty payments, anything like that could help benefit her financially, but also protect her name, her reputation, and her business's reputation as well.
Do you find that people are reluctant, business service providers are reluctant to send such a hefty document? Are they afraid that it's going to, frighten away their clients potentially? And if so, what do you do?
Yes, for sure. And I think a lot of it depends on the industry. It depends on the individual who is my client, but also the individual who my client is contracting with. I tend to give my clients the option. They know their industry better than I do. And so I'll tell my clients, what is your relationship like with the party that you're contracting with? Is this a friendly relationship? Have you worked with them in the past? If so, then I don't mind just shooting out the contract myself. They know that, they know that you're reputable. They know that you're going to do what you say you're going to do. They're not afraid of lawyers. Usually that'll work out perfectly fine like that. I have other clients who are in industries that are a little bit more skeptical of lawyers. And so a lot of times I'll draft a contract for them and I'll send it to the client and say, I can send this to the opposing party if you'd like, or sometimes it's just simpler to give them a contract, and the two business owners negotiate the terms of the contract. They can mark it up and then send it back to me and I can edit it. And I do that quite a bit because some business owners just don't want the people that they're working with to know that they have attorneys involved. It scares them. So, we're happy to be flexible and be as visible as you want us to be. Sometimes you want us to be super visible if you're, trying to strong arm somebody. You were going to put, letterhead on on the letters and everything. So there's definitely different ways that we can approach it, and we're happy to tailor it to whatever you guys need.
Well, and you mentioned the idea of, some industries having being a bit contract opposed, or the potential of being overwhelmed or intimidated by that process. Do you ever suggest like a progressive process in which you're like, all right, so can we send one contract that's really easy to read with just the bare bones and be like, okay, we agree here. And and then move and be like, all right, well, let's get into the nitty-gritty on this area, and start getting into the weeds in one area and be like, yes, we agree here, right? Rather than sending a 10-page document that might feel overwhelming and a lot to commit to all at once.
Yeah, I've done that a lot, especially with the consultant that I was talking about earlier. She'll enter into contracts to perform services, and then sometimes the client will say, I'm happy with this, the services contract, but I'm a little bit weary about these royalties. Can we do a separate royalty agreement? And that's how we'll get the work started immediately, and we'll worry about the royalties later. That's one that happens pretty frequently, but I've seen it a lot in other realms too.
That's helpful. Thank you.
Mhm.
Cynthia, Nathan, Candace, anybody want to ask a question or share a challenge that they've heard about, and we can brainstorm it with or workshop it with Shelby to see how it could be avoided in the future?
I guess one thing that I had when I was, opening my practice, I had certain things that I had seen in a contract, that other direct primary care doctors had as far as with their clients. And the person I was working with, took it, and then they kind of made it much bigger. A lot more words, and I was kind of left with a feeling like, what was wrong with the first version? Because now it's got like a page and a half, and I'm like, yeah, and this is the lawyer page, you can read it if you want. To avoid that kind of thing happening in the future. I mean, I felt like, okay, I'm not a lawyer. If it didn't need to be in there, they wouldn't have added it, but it made something very, that to me seemed clear, to now something very not as clear.
Yeah. And I do think that happens a lot. I would be cautious. Some attorneys like to bill for the sake of billing. So they'll have a contract sent to them by a client who has hired them as general counsel. And usually when somebody hires you as general counsel, they just send you documents continuously and you just review them as they come in. But say you get a contract and it looks pretty good, but you're like, well, I can't just tell them, yep, it looks good. And they want to add something to it to, show that they've added value to it. So I do think that there are some attorneys who will just add provisions to contracts for the sake of being able to bill that. I also think that there are some provisions that are necessary, and there are like indemnification clauses are usually pretty like kind of hairy to read through. They don't make a whole lot of sense, but a lot of contracts have them, and they can be necessary. You want to make sure that somebody else is going to be responsible for indemnifying you if something were to occur. So that's something that sometimes is necessary, sometimes is not. Jurisdiction is something that sometimes people leave out of contracts, but can be important, particularly if you are practicing both in Kentucky and Ohio. Where do you want to litigate if you were to get sued? That's something that you might want to talk to an attorney about, what state is most friendly to physicians or to your practice. that might be a clause that you want to include in there that might not have originally been in there. But yeah, I always request anytime I send somebody a contract and they send me back changes, I almost demand that they be redlined. I'm not sure if you're familiar with like redlining documents at all, but it highlights every single change that they made throughout the entire document as they're making them. That way you can look at the agreement and see exactly what changes are made. So you're not, getting the wool pulled over your eyes or anything like that. I think Adobe also has a function where you can upload 2 documents and it will compare them for you and highlight any changes in the document. So those are tools that I use pretty regularly if somebody's trying to pull a fast one on me and say, oh, here's an agreement, and I notice it looks a little different than it did when I sent it to them. That's something that I will use to make sure what is being changed and is it a change that I find acceptable. Sometimes people will just squeeze in the word reasonably in between something. So you may say they have so and so must reimburse you within a reasonable amount of time. Reasonable is not specific enough for me. I want to be reimbursed within 14 days. So those are things, they may add reasonable instead of 14 days. They may just add the word reasonable to give themselves more of a buffer for things. Words like reasonable are modifiers. So it gives you a little bit more of a gray area as to decide what is reasonable to the average person. So I always tell people to be careful when you see the word reasonable in a contract, read the full sentence and see worst case scenario, what is the most unreasonable thing that somebody could request of you, and expect that because it's usually how it works. But yeah, I tend to read contracts in a very skeptical view just to imagine worst case scenario, because the second you don't imagine worst case scenario is when the worst case
Shelby,
scenario.
that's your job, my dear. Your job is to be skeptical and to scrutinize and to think of all the things that could possibly go wrong so that you can protect your customer or your client.
Sure. Yeah, so that is one piece of advice I definitely recommend to anybody, whether you're just reading your lease at home, or if you're just signing your terms and conditions online. I'm not going to say that I read all those because I don't, but definitely any contract that you're investing substantial money in, just make sure you're reading it through and with a skeptical lens. Even if they are your friend or your family, those can sometimes be the more complex contracts because your guard's down a little bit.
Shelby,
Did that answer your
Candace has a
question,
question. Cynthia.
I just want to make sure Cynthia's question was answered. Yeah.
Okay.
Good. Okay. Thanks. Yeah. Go ahead and read Candace's question, Jess.
Sure. So she's saying that she understood that federal law is changing soon for non-competes. In your professional opinion, will we be seeing more non-disclosure contracts versus non-competes? Is that?
Yeah, for sure. Yeah, we're not going to be seeing any non-competes anymore, with the exception of CEOs and other high-level executives. Those are the only time that non-competes are going to be permitted. I think the idea behind that is those individuals have more access to trade secrets and inside information of the business. So, they do see the value in a non-compete in those situations. But the federal government has decided that non-competes limit the American citizens' ability to find meaningful work that is, and by meaningful, I mean that compensates you for what you deserve to be compensated. It's really common now for people to only stay at a job for 3 to 4 years, and move to another job to get a raise, those sorts of things. This is hoping that employers will just pay their employees, a reasonable fee to keep them, because now they can leave and they absolutely have every right to leave. So you want to make sure that you are giving your employees incentive to stay, whether that is money or remote work or what have you. But one thing that you can do to protect yourself is those non-disclosure agreements. Like I said, for CEOs, a lot of it has to do with trade secrets, inside information of the business, processes. I have a couple clients who are in a very niche industry with vintage spirits. And so there are very, very specific laws about how you can purchase vintage spirits, because a lot of them were produced prior to, the FDA or anything like that. So there are very specific laws when it comes to vintage spirits, and there are very specific processes for those. My clients who work in that industry hold those processes very close to the vest, because there just aren't very many people doing it right now. And, having a monopoly on the industry is obviously helpful to their business. So those are things that I'm working very hard to get them some very clear non-disclosure agreements, so they cannot take the processes and the different procedures that they use and take them to start their own business. And, bourbon is such a huge industry right now. It's growing like crazy. So we don't need any more competitors. So we try and do our best to limit any kind of competition amongst our clients.
That's great. Candace said, thank you. All right. Well, if there are no other questions, we'll end. And as I mentioned, we'll share out the replay. So Shelby, thank you so much for your brilliance and these great examples and the specifics about contracts. Yes, super, super helpful. So thank you very much. And we will follow up with Shelby's contact information too for everybody who registered.
Yes. Awesome.
Thank
Thank you
you
guys
so
so
much.
much.
Bye.
Bye.